Agora ouviremos o professor Peter Sester, que vai falar sobre o tema que estava destinado ao professor Peter Nobel, que não pôde comparecer por razão de saúde, e tratará da arbitragem internacional de investimentos, progresso e desafios recentes. Sua Excelência, a palavra.
E é uma grande honra de participar neste painel com os ministros Araújo e Rosado. Infelizmente, o meu colega Peter Nobel não podia vir por causa de um problema de saúde grave que aconteceu no último momento, mas ele preparou uma palestra e ele me pediu ler esta palestra para vocês. A palestra está em inglês e ainda não são capazes de traduzir a palestra espontaneamente, mas a gente tem uma tradutora que certamente vai fazer um ótimo trabalho. Bom, então eu vou começar com a palestra em inglês. Arbitration is in international disputes still the preferred and most important dispute resolution mechanism. It has in modern, like in ancient times, also encompassed arbitration between private parties and states. This is the domain of investment disputes, where states have become rather normal actors in arbitration about commercial matters, particularly in investment matters. We speak about ISDS, Investor-State Dispute Settlement. Here the challenges lie. The most relevant center is the ICSID Center in Washington, as our colleague Rosado just mentioned. ICSID stands for International Center for Settlement of Investment Disputes and belongs or was initiated by the World Bank Group. The ICSID is one of the 5 international organizations that make up the World Bank Group. However, it is not a special agency pursuant to Article 57 of the UN Charter. The ICSID was established under the leadership of the World Bank. Its founding document and the legal basis is the Convention of 1965 on the settlement of investment disputes between states and nationals of other states. As of June 2014, there were 159 signatory states and 151 contracting states had ratified the convention. Switzerland was among the first to ratify already in 1968. As we just heard, Brazil is not a signatory state. Brazil, since a long time, has been reluctant, as far as I see, to allow investor-state disputes. However, this might change, as we will see in a minute, in the near future. In the first 30 years of its existence, the ICSID supervised, in average, only one case annually, so a very minor role. But as of 1995, the number of cases has increased significantly. In 2008, ICSID registered a record increase of 48 requests to settle investment disputes. From its launch to January 2010, there were 350 cases. 73 had to deal with questions of bilateral and multilateral investment treaties. The center is not a court by itself, but provides a framework for the panels dealing with the specific cases. A number of South American countries have signed and ratified the Washington Convention, although Bolivia, Ecuador, and Venezuela recently withdrew their membership. You can easily imagine why the politics in Bolivia, Ecuador, and Venezuela shifted away from a rather investment-friendly approach. As of the end of 2014, Germany has signed a total of 136 bilateral investment treaties. 127 of them are in force, and this makes Germany the leading country with regard to bilateral investment treaties, followed by the Republic of China, 125, and Switzerland with 120 treaties. It's not by accident that Germany, Switzerland, and Chinese are heading the list. All the three countries depend heavily on exportation, international business, and foreign investments, and they need to protect their investments, particularly in dubious jurisdictions. As you can see, Germany never entered into an investment treaty with its most important partners. Obviously, Canada, the US, Australia, Japan are much more important than all these African countries. However, the German industry and the German government trusts in the jurisdiction of these main partners, where we do not need special protections because we expect the local judges to treat our investors, our firms that invest there, just in the same way as they treat locals. I would like to mention, and this refers to what I said just a minute ago, that Brazil last year signed bilateral investment treaties with Angola and Mozambique. And both treaties contain also a dispute resolution mechanism, a two-step approach, first mediation and then an interstate arbitration mechanism. It's an ad hoc mechanism. It's not, obviously, because the Washington Convention is not ratified in Brazil. It's not submitted to ICSID, but it's an interstate arbitration mechanism that was established. Let's have a look at the proceedings applicable in the course of ICSID arbitration. Proceedings before the ICSID follow roughly the same rules as private arbitrations. However, they have some special features, such as the selection of the arbitrators from a non-binding panelist and the limited remedies, allowing, however, also an annulment request to an ICSID annulment committee. The Convention says that the rendered awards must be immediately enforced. This is like under the New York Convention. I would like now to take your attention to the WTO system. Settling disputes in a timely and structured manner is a key issue of the WTO system, which is located in Geneva, Switzerland. It's a procedure that helps to prevent the detrimental effects of unresolved international trade conflicts and to mitigate the imbalances between stronger and weaker players by having their disputes settled on the basis of clear rules rather than having power determine the outcome. It's just like the Swiss ambassador mentioned this morning, international arbitration and international law is basically a mechanism that helps smaller, peaceful, and not so powerful countries to protect their interests and protect the interests of their individuals and enterprises. After the entry into force of the WTO agreement in 1995, the dispute settlement system soon gained practical relevance. This is especially true for Brazil and to a certain but limited extent also for Switzerland. Whereas thus far Brazil has been involved in 142 cases, Switzerland has been part to as little as 15 cases. Particularly famous are the disputes between Brazil and the EU about banana exportations. In the latest ongoing case, Brazil has lodged a complaint against Indonesia concerning the importation of chicken meat and chicken products. The current dispute settlement system is embodied in the Understanding on Rules and Procedures Governing the Settlement of Disputes, commonly referred to as the Dispute Settlement Understanding, DSU. Today, the DSU constitutes Annex 2 to the WTO agreement. A crucial factor concerning the dispute settlement system is that only WTO member states can bring claims. This means that private individuals or companies do not have access to the system, although they are often the ones most directly and adversely affected by the measures allegedly violating the WTO agreement. Concerning the procedures, in the first period of the proceedings, which lasts for 60 days, the members are obliged to try to find an amicable settlement. Usually, the panel consists of 3 experts who are representatives from members that are not involved in the conflict. Usually, these experts are former representatives of governments or university professors. The panel is required to interpret the treaty according to the Vienna Convention on the Law of Treaties, and it must decide within 6 months if an infringement of a WTO agreement has taken place. Against the decision of the panel, a member has the right to lodge an appeal to the appellate body. The appellate body consists of 3 judges that are assigned to a case. These 3 judges are part of a total of 7 permanent judges that are experts without any connection to government and appointed for 4 years. All questions of law can be challenged within the appeal, and the proceedings cannot take longer than 90 days. The possibility to appeal makes the WTO dispute settlement mechanism unique among the judicial processes of dispute settlement in international public law. Furthermore, the DSEU addresses questions of compliance and retaliation. In recent months or years, the criticism about investment dispute resolution by arbitration, basically by ICSID, has increased also within the European Union, particularly due to pressure made by Consumer Protection Association and some governments critical with regard to globalization and privatization. The EU, who has since September 2009 the sole competence for bilateral investment treaties and investment protection agreements, has newly considered the independence and transparency issues and the concern about policy space for governments most relevant. The intention is to safeguard the right of the state to change legislation and regulation over time, which eventually also means to change investment conditions, which is a hard point because investors depend on long-term contracts, on the stability and enforceability of long-term contracts in order to have the legal certainty to make investments that will only bring amortization after years. In the ongoing negotiations between the EU and the US, the European Union refuses to implement an arbitration clause in favor of ICSID. Instead of this, the European Union wants to establish a special investment court system, and this indeed represents a very challenge for investment arbitrations as we know it so far. In particular, the EU would like to apply this new system to the free trade agreements. Most recently, in the free trade agreement that was signed and ratified with Vietnam last year, as this approach was for the first time used. In addition, this, as I just mentioned, this mechanism for investment dispute settlement should now be put into the transatlantic trade and investment partnership with the US called TTIP. In the current phase of negotiation, it seems uncertain whether the USA will accept the new EU approach or insist on investment arbitration within the World Bank settlement. However, I don't think the US can really insist on this, because the political situation in Europe is so that no government can, in this moment, pass a free trade agreement, an investment treaty, which refers disputes to ICSID arbitration. However, in the long run, and this in order to consolidate the dispute resolution mechanisms, a kind of investment dispute center based on the WTO model, and hopefully due to the neutrality and expertise, just like the WTO in Switzerland. This is all still law in making, but there, at least within the European Union, this seems to be the favored approach. As core elements of this new investment dispute settlement scheme, the following points were announced by the European Commission in a press release dating from September 16, 2015. There should be a permanent court of fourth instance and a permanent court of appeal, just like in the WTO system. The judges should bring along high qualifications, and the possibilities of investors to bring a case in front of the courts are clearly to be defined and restricted. The right of government to adopt and change legislation and regulation over time must be guaranteed and shall not be undermined by the system. With reference to the existing concept in the EU, the following shall be ensured as well. Proceedings are transparent, public, and all documentation must be publicly available. Parties who have an interest to join the case shall have a right to do so. Forum shopping is not allowed. The occurrence of several proceedings about the same topic are avoided. Unfounded claims must be refused promptly, and the law of nations and national laws are clearly confined from each other. According to the new idea of the EU, the court to be created shall be solely responsible for the scope of the TTIP agreement and be constituted by 15 publicly authorized judges. 15 judges are jointly elected by the governments of the US and the EU. 5 judges should be named by the US, 5 judges by the EU, and 5 by third countries. The cases should be dealt by 3 judges. The composition of the court should take place by coincidence, but always comprise 1 judge from the US and 1 from the EU and 1 from a third country who would be chairing. In no way shall the parties be able to influence the composition of the court. The new Court of Appeal would serve as an appellate body and shall be composed of 6 members jointly elected by the US and the EU. Those members would be elected for 6 years, and of which 2 shall come from the US, 2 from the EU, and 2 from third countries. And now I come already to a key topic that is where we miss basically Peter Nobel, because he is the expert in transactions related and arbitrations related to Russia. Russia seems to adopt in recent years a new challenge to international disputes, which is the policy of non-recognition of awards. Under the heading of UCO's shareholders versus Russia, we have seen a series of international court cases seeking compensation from the government of Russia to the former shareholders of UCOS, a large oil company, based on the claim that Russian courts were not acting in good faith in criminal proceedings against UCOS accused of tax evasion, which have led finally to the bankruptcy of the company. It is most interesting to go through these cases and also the various settlements, but I look only a bit further into 2 of the cases and the legislative aftermath. In 2005, GML Limited, formerly Group Menatep, the former owner of 60% of UCOS, filed a lawsuit under the Energy Charter Treaty before a tribunal at the Permanent Court of Arbitration in The Hague. The Energy Charter Treaty is a kind of investment protection agreement, a multilateral agreement. The case is the award that was taken by the Permanent Court of Arbitration in The Hague is in annulment proceedings in the Netherlands. The court in The Hague found anonymously that an expropriation had taken place, with that Russia having expropriated the UCOS oil company in a series of politically motivated attacks in breach of Article 13 of the Energy Charter Treaty. In particular, the channel said Russia was not driven by motives of tax collection in auctioning off a core business, but by the desire of the state to acquire UCO's most valuable assets. However, the arbitrators docked 25% from the value of the attributed they attributed to the assets seized. The Russian Foreign Minister Sergei Lavrov said in television comments that Russian entities affected by the decision of the court in The Hague were preparing to go to court to force the freezing of the assets of foreign companies with government involved in Russia. The case is, however, as I mentioned, still pending in an annulment proceedings in the Netherlands. The former management of UCOS submitted an application to the European Court of Human Rights. UCOS claimed in their ECHR argued that the company's rights protected by the European Convention on Human Rights were violated in Russian courts, which led to its bankruptcy and liquidation. It also argued that UCOS has been singled out for discriminatory treatment. UCOS officials complained that their rights were breached under several articles of the Convention. Following an admissibility assessment that took 5 years, the court declared the UCOS application admissible on 29 January 2009. This was a significant achievement for UCOS, as the European Court of Human Rights declared overall admissible only less than 5% of all submitted applications. The court announced that the Russian state violated the human rights of UCOS by agreeing that there had been a violation of UCOS' right to fairness in legal proceedings in relation to a tax reassessment for 2000. The court also established that there had been a violation of the right to protection of property through enforcement proceedings carried out over tax assessments from 2000 to 2003. The interpretation of the tax liabilities which were applied to UCOS was foreseeable, but the court still noted that the crux of the case was the rapid and inflexible enforcement of those liabilities. UCOS has been effectively paralyzed because all of its assets were frozen from the first assessment. The proceedings were complicated, but now addition could be executed. However, in this moment, a new obstacle appeared. On June 15, 2015, more than 19 deputies of the Russian State Duma sent a request to the country's constitutional court to clarify how ECHR writs of execution should be applied in Russia. On July 14, 2015, the court ruled that ECHR judgments did not override the preeminence of the constitution in the Russian legal system, and that Russia can step back from its obligation if that is the only way to avoid violating its constitution. However, the judges also said that they had not yet reviewed the ECHR decision on UCOS since the case had not been filed to the Constitutional Court. An amendment to the federal constitution law, the Russian constitutional law, regarding the Constitutional Court of the Russian Federation laid the basis for a new discussion. This amendment enlarged the competences of the Constitutional Court to the extent that it became responsible for reviewing the possibility of enforcement of decisions by international bodies for the protection of human rights. If the court finds that the decision of the European Court of Human Rights contradicts the Russian Constitution, it declares it as non-enforceable on the territory of the Russian Federation. This is obviously in contrast to the classical doctrine in international law regarding the hierarchy between international and national law. The goal of the amendment is meant to preserve the sovereignty of the Russian Federation and to create an instrument to ward off tendentious decisions of international courts that ask for exorbitant compensation for damages that must be paid from the budget of the Russian Federation. According to the authors of the initiative, the amendment does not only comprise decisions of the European Court of Human Rights, but also of other international courts. The wording of the amendment also talks more abstract and not only of decisions of the European Court of Human Rights. The upcoming case law of the Constitutional Court will further clarify this issue. We wait and see. It's not a healthy development of international law, but as you can see, Russia is adopting in many ways recently a different approach to international relations. Let me sum up. Arbitration is still a very strong device for international private disputes. In the field of investor-state disputes, the international tide seems, however, after a long quiet period, to change, and the state participation in arbitration is seen more critically in several countries. The big American law firms and their sometimes aggressive fee approach are sometimes by the cited as the root of this skepticism regarding the classical investor dispute resolution system in Washington. The improvement of transparency, independency, and professionalism are the newly declared goals, particularly by the European Union. Based on criticism without much of an empirical background, it is clearly intended that future free trade and investment treaties will resort to specific permanent court institutions. The states want to be more at liberty to regulate new issues, even though potentially conflicting with old contracts, and thereby creating a less attractive environment for international investors. Organizationally, the WTO system serves as a model. The appellate setup is regarded to be important, as you also mentioned before. The ICSID might lose some of its importance. However, 3,000 in bilateral investment treaties are in place, which will over time still generate a significant number of cases. We have to notice an important turn, to some extent, the approaching end of arbitration with the state party. The Russian national approach, however, is a specific problem, despite of being situated at the level of the Constitutional Court. All this is not a step ahead in the development of a system of international law, when the international awards can be disregarded in a participating state. The appropriate answer of Russia, if they don't agree with the jurisprudence of the international courts, would be to simply withdraw its participation. But obviously this is not what they want, because they want to pick specific cases, and simply, if they come to the conclusion that this specific award is not in their interest, to reject the execution. Thank you. Obrigado.